Hi, I'm John Dearie, and welcome to this edition of Face to Face. There's probably few areas of the law, especially where people are injured, that fall more into the category of what we'll talk about today, and that is motor vehicle accidents. And as is always the case, so pleased to have a very experienced, and we're very happy to say this will be the first time that she will be appearing on our face-to-face program, and that is an attorney in our office, Lindsay Harriman, who has herself substantial experience in the personal injury field, and we will discuss, as I indicated, motor vehicle accidents. So, welcome, Lindsay.
Thank you, Mr. Dearie.
Let's get started, because I think if someone is in a motor vehicle accident, a passenger, a driver, a pedestrian, whatever, probably there's two words that they need to understand almost at the beginning, and those two words are no fault. So why don't we begin there by talking about what does no fault mean, because it's integral as it relates to motor vehicle accidents, injuries, and treatment.
Absolutely. So no fault in New York. New York is one of 12 states since 1970 that has enacted no fault laws. And basically what that is that insurance companies are required to pay up to $50,000 in basic economic loss to somebody that's injured in a motor vehicle accident. And the basic economic loss can go to medical expenses for injuries related to the accident, lost wages of up to $2,000 per month, and also out-of-pocket expenses.
Now, does that mean, and how does that relate to what we would know as a lawsuit, for example? Is that, as you outlined, the so-called no fault, is that the only benefits that an injured person in a motor vehicle accident would be entitled to?
Well, depending on the injury, of course, you can also be entitled to something called pain and suffering. But it definitely depends on the severity of the injury.
There is something inherent to the whole notion of no fault, and I guess it goes under the title of serious injury, which means a category in state law that identifies, I guess it's about 9 or so different categories. Maybe you touch on a couple of them.
Of course. There are 9 different categories that signify a serious injury. Some of them would include death, disfigurement, significant disfigurement, fracture, loss of a fetus, permanent loss of use of an organ, permanent limitation of an organ or a body part, significant limitation, and then also if you have a medically determined injury that prevents you from doing your daily activities for over 90 out of the first 180 days after an accident.
So what does it mean? Let's say, for example, let's use the example of someone who is a passenger in a vehicle, and they're in an accident, irrespective of the kind of accident, and they wind up with some kind of a fracture. Where does that put them in relationship to no fault and in relation to what you had described as pain and suffering?
Well, if you sustain a fracture, that means that you pierce the threshold and therefore you have a serious injury, and you will be able to be compensated through no fault and therefore for your pain and suffering.
You will be entitled to the pain and suffering, but are you not also entitled with a fracture to initiate a lawsuit for recovery for pain and suffering, as contrasted to someone who suffers, let's say, a so-called soft tissue injury, in which they may then be limited just to the no-fault benefits?
Oh, absolutely. If you sustain a fracture, if you hit any of those 9 categories, then you can not only can you collect under no fault, you can surpass that, file a lawsuit, and then that opens you up to further compensation.
When you talk about fracture as kind of being almost the line above whether you're in pain and suffering or below fracture, while there are other, obviously, death and dismemberment and things of that nature, someone loses an arm in an accident, of course that's a serious injury. But it does seem to me that the fracture, from a practicing perspective, that is really the criteria of whether you're above and are able to get pain and suffering, or whether it remains a soft tissue injury. Let's use the example of a soft tissue injury. What does that really mean, and what does that impact does that have on your injury treatment and your subsequent compensation?
Sure. Soft tissue injuries can, first of all, they can be in certain places of your body and certain body parts. Tendons, muscles, these kinds of things, in your shoulders, in your knees, they can be torn. It's a torn ligament. It is not something like a fracture with a bone. That is considered a soft tissue injury. Certain traumas to the spine, to the cervical, which is your neck area, and the lumbar, something like a bulge or a herniation, it has to do with the little cushions in between your vertebrae. If they get damaged and they sustain trauma, any damage to those body parts, like I just discussed, that is soft tissue. It is those little cushions. It's not something like a bone. It is considered soft tissue.
If it is soft tissue, what benefits are you entitled to? Are you limited then essentially to no-fault benefits, the $50,000 that you touched on earlier?
That's an excellent question. You are not necessarily is the best answer. You know, if you have a soft tissue, would you be open to no fault? Of course. That is an injury. But to sort of pierce the threshold and get further compensation, there are other factors that would determine that. It does make a case more difficult.
You mentioned other factors. What might some of those other factors be to evaluate whether a person with a soft tissue injury still may be entitled to something other than the no-fault benefits?
Okay, so another determining factor, if you have soft tissue and your doctor evaluates you and examines you and says you actually cannot go to work, you would fall into that last category of a medically determined injury that puts you out of your daily activities for the 90 out of the first 180, meaning if your doctor tells you you cannot go to work for greater than 3 months within the first 80 days of the accident and you just have a soft tissue injury, you will pierce threshold.
So in other words, that 180 and 90 days is a criteria that suggests even though that it's a soft tissue injury, it's a serious injury and it has impacted your life essentially.
That's exactly correct.
We always talk in our face-to-face about something that most people know the terminology, and that's statute of limitations. So there is obviously a statute of limitations for personal injury across the board. Tell us about it as it relates to motor vehicle accidents.
Sure. The statute of limitations is the amount of time that an injured party has to file a lawsuit. And in New York State, for a motor vehicle accident, they have 3 years to file that lawsuit. So for example, today is December 11th of 2018. If someone were to get into an accident today and be injured, that means you have until December 11th of 2021.
So you have a 3-year statute of limitations.
That's correct.
Suppose you have Mr. X and Mr. Y and they're in an accident. That's a 3-year statute of limitations.
That's correct.
What happens if Mr. X is driving and is in an accident with the City of New York Department of Sanitation truck? What happens then?
That's a very good question, because if you are in a motor vehicle accident with a municipality, let's say a sanitation truck, a police vehicle, first requirement, you must file a notice of claim within the first 90 days of getting into that accident. This is why it's extremely important, if you do get into an accident with a municipality, that you contact an attorney. This is required, a notice of claim within the first 90 days. If you don't do that, your case will be barred. Then following, after the notice of claim is filed, you have 1 year and 90 days to commence the lawsuit.
How strict are the courts with regard to both a 90-day filing of a notice of claim and the filing 190 days essentially, as contrasted to 3 years when you don't have a city or a state or other governmental entity there? How strict are they with regard to those statutes?
There are very few exceptions that you will ever get by without filing those documents. So they're extremely strict, very, very rigid. These are required documents. It's very necessary to put the city on notice.
It is amazing. And what about that, talking about statutes, what is the statute of limitations as it relates to no-fault filing for a person to have the benefits of no fault?
It is required that an individual file a no-fault claim within 30 days of the accident. If you don't file that, there is a very good chance that you will be barred from those benefits.
That is really amazing, isn't it, how brief that period is? I mean, I know we've all experienced that situation where the person comes in 6 weeks later and finds out, they've lost the benefits of no fault. Is there any opportunity to file with the court and have, if there are certain circumstances, maybe somebody's language issue or some other factor, is that notice of claim ever able to be overcome if the person does not file it within the 30 days?
There are some exceptions to this rule. Again, it's extremely important if you are in an accident with a municipality to then, seek out an attorney. So, that attorney can contact the court and draft the proper documents asking for permission for the extension to file.
One of the sad factors that comes up in motor vehicle accidents is often, more frequently than we'd like, a fatality. And what happens to an individual's case? Let's use dad as a salesman, and dad's out on the road and has 2 children and a wife and is in a fatal accident. What happens under those circumstances? Is there still a case to move forward?
Yes, there absolutely can still be a case. There would be something called, a wrongful death suit, and it would be up to usually one of the beneficiaries of the lawsuit. So it would be typically a relative. They would basically step in the place of the plaintiff and file suit as, in their shoes, essentially, a wrongful death act.
We're dealing in the real world with the issue of immigration all of the time, and there's no doubt in the greater New York area there's a substantial number of individuals that are out of status with regard to their immigration status. If a person is in an automobile accident and is essentially illegal from an immigration status, are they still able to bring an accident if they were in a motor vehicle accident or any other kind of accident?
Absolutely. Your immigration status doesn't have any effect on your ability to file a lawsuit and be compensated for your injuries. So, you are correct that some people may believe that their immigration status can have effect on their ability to do this, but in reality, it has zero effect. They still have the same rights to move forward with a lawsuit.
Do you, I don't want to use the word enjoy, but if someone has been in a motor vehicle accident or any other kind of accidents, you deal with such a broad range of them in our office. What is an interview when someone comes in? What can they expect in terms of discussing with you as the potential attorney? What are you looking for in terms of that initial interview?
Well, first, all of the initial interviews, everything is a free consultation. We here at the Dearie Law Firm, it's a contingency fee basis. Hopefully with cases coming in, if we can reach a judgment or a resolution, a settlement, we will only take our third if the person is compensated. When they first initially come in, they would meet with myself or another attorney. We get all of the facts. We discuss the liability, what happened, who was in the wrong, and we discuss the injuries. We make sure that the person also, if they are unsure as to who to go to for medical treatment, we stress the importance of them getting well and getting the treatment that they need.
Someone is in an automobile accident and is not seriously injured, so to speak, where there's an ambulance and immediately to the hospital. How important is it for an individual to take a photo, let's say, of the cars or the impact of the collision between both?
Just like in motor vehicle accidents, in all accidents or possible personal injury claims, it's extremely important to take photographs of the accident itself. There are many different factors, whether damage to the vehicle can then be taken to auto body and be fixed, the surrounding elements, all of these elements can be quite fleeting. So only at the moment. So really the importance of a photo, we are not there. It's only the plaintiff and the defendant that are there. However, this is sort of the evidence to build a case, and it gives perspective to future jurors, to judges, to the insurance, and to other attorneys. It's crucial.
There are different kinds of accidents. We've seen them. Someone is driving, they get hit from the right, they get hit from the left, they're making a left turn or a right turn to get hit from the rear. What is the significance, if there is, of how the accident occurred in relationship to how the injuries are?
Well, also, that's a good question because it also plays into the notion of taking photographs. Points of impact, one, it helps to build evidence on liability, especially if it's two cars. Somebody has one story, another person has another story. It's a he said, she said. We can look at the points of impact. Also, as it pertains to an injury, the points of impact. Okay, if you're getting hit from the left and then you get pushed to the left, your shoulder, if you're the driver, your shoulder hits the door. That makes sense that you then have a shoulder injury, a shoulder tear. So it's crucial, really. If you're hit from behind, you get pushed forward, you get moved back. This can cause trauma to your cervical, your lumbar. It's extremely important, the points of impact.
What is the impact of a so-called rear hit accident where you are driving and you get hit directly from the back? Is there any presumption in terms of liability under that circumstance?
Absolutely. In motor vehicle accidents, well, let's say in New York State, there can be an allocution of fault between the plaintiff and the defendant. The better a case is when there's 100% liability on the defendant. Sometimes we don't have that. However, in a hit in the rear, it is almost 100% time exclusively that all of the liability is going to be on the defendant. Because why? The plaintiff is moving along and they are hit from behind. They are not hitting anybody. Well, they could be potentially pushed into somebody, but essentially the force is being put onto them from behind. So therefore, that's 100% liability for the most part on the defendant.
You mentioned a word before as it relates to the fee, the legal fee to represent an individual. And I think it's important, finally, maybe for you to underscore what that term contingency means and whether there are any out-of-pocket expenses for that person that was in a motor vehicle accident.
Absolutely. For a contingency fee basis that we are at the Dearie Law Firm, there is no out-of-pocket expenses for the plaintiff. We pay for everything. We do all the investigative fees, and we only become compensated if we can provide compensation for the plaintiff, which is 1/3.
I think we touched on an awful lot. Thank you very much.
Thank you.
Really a pleasure to talk with. Hope you all enjoyed our face-to-face with Lindsay Harriman.